What is governance? Governance is a complex concept. There are many different definitions. IUCN defines governance as the interactions among structures, processes and traditions that determine how power and responsibilities are exercised, how decisions are taken, and how citizens or other stakeholders have their say. Ultimately, governance is about power and authority. Law determines who has power and authority, how power and authority is exercised, and how those exercising power and authority are held accountable. Law determines who is involved in protected area governance. This can include protected area managers, legislators, law enforcement agencies, judges, tribal governments, landowners, natural resources agencies, development agencies, municipal authorities, local residents, indigenous peoples, NGOs, research institutions, faith organisations, tourist operations, private companies, and individual resource users such as fishers, hunters, farmers, livestock herders, and gatherers. Law identifies relevant actors. Law sets out powers, functions, rights, and responsibilities of these actors. Law creates processes for participation and mechanisms for accountability. Law determines how decisions are made, and power is exercised in the context of protected areas. Law prescribes what types of decisions can be made, who is involved in making decisions, how decision-making is carried out, possible outcomes of the decision, and how decision-makers are held accountable. Types of governance. There are diverse types of governance based on allocation of power and authority. Governance by government or state-based governance is the classic approach, under which national or subnational government owns or controls a protected area and holds complete responsibility for management and decision-making. Governance by indigenous and local communities describes situations where indigenous peoples or local communities exercise control and management authority over areas to which they have ownership or resource use rights. When managed for long-term conservation, these areas are called Indigenous and Community Conserved Areas, or ICCAs. Law can provide frameworks for ICCAs to be incorporated into formal protected areas systems. Private governance is governance by individuals, corporations, NGOs or other private entities over areas they own or control. Like ICCAs, private protected areas, PPAs, can be incorporated into formal protected areas systems through conservation agreements or other legal mechanisms. Shared governance describes governance exercised by multiple entities through formal arrangements or joint institutions. Governance can be shared between or among sovereign states, tribes, subnational territories, communities, and private entities. Law determines what types of governance are available and what type is used for a specific site. There can be multiple governance types within a single protected area. Governance quality. Governance can be evaluated in terms of quality. The concept of good governance encompasses principles of public participation or voice, transparency and accountability, predictability, fairness and equity, and access to justice. Law should provide mechanisms to realise these principles in all governance types. Main messages. Protected areas governance is a complex concept. It fundamentally deals with power, authority, and accountability in decision-making. Protected areas law should ensure all relevant stakeholders are meaningfully involved in decision-making. Protected areas law should define clear and participatory processes for decision-making and exercise of power and authority. Protected areas law should recognise and support diverse types of governance. Protected areas law should provide mechanisms to ensure the realisation of good governance principles.